Good morning. Welcome back to the session on Isbp. In this session, we shall discuss transport documents covering at least two different modes of transport. Transport document covering at least two different modes of transport. Paragraph D1 to D32. First, ISBP helps us understand when Article 19 of UCP is applicable. If there is a requirement on the credit for a document covering movement of goods utilizing at least two different modes of transport. If there is a requirement covering movement of goods utilizing at least two different modes of transport, then Article 19 will be applicable. It can be called as multimodal or combined or whatever, and it should not indicate that shipment has been affected by a single mode. It should not indicate shipment has been affected by a single mode, and it need not indicate the number of modes used. It may be silent whether 1, 2, 3, any number of modes used, but it should not say it has been shipped by a single mode. And credit should call for a document covering at least more than one modes of transport. It should not indicate it is subject to charter party. The document should not indicate it is subject to charter party. And if the credit requires other than a multimodal, but it is clear from the routing that the place of receipt or a final destination has been given, which is a landlocked place, and definitely even if a BL or anything else is called for, it requires a multiple modes of transport, then a multimodal transport document can be submitted and it has to be examined under Article 19. And the document need not be titled as MTO or MTD or CTD or whatever. Regarding issuance, carrier and other things, the document may be issued by any entity other than the carrier. When we look at UCP, it will say it has to be issued and signed by, and ISBP helps us to clarify, saying it can be issued by any entity other than the carrier. And provided it means the signing requirements of Article 19. The document can be issued by any entity other than carrier and master, provided meets the article. So this helps us to take care of agent issuing the document or freight forwarder document or a house BL and things like that. If the credit indicates freight forwarders or multimodal transport document available acceptable or house multimodal transport document acceptable, then it may be signed by the issuing authority, whoever is issuing, that is the freight forwarder or the multimodal transport operator, and they need not indicate their capacity and they need not indicate the name of the carrier. Basically, ISBP helps us to understand that the transport document, multimodal transport document, if called for in the credit and if being examined under Article 19, can be issued by any entity other than carrier also, provided Article 19 signing requirements are met. If the credit indicates freight forwarder's document is acceptable, then it can be signed by any entity without indicating capacity, without indicating name of carrier, so that carrier need not be identified. Earlier, we used to have situations where lots of banks were indicating carrier not identified as a main discrepancy in multimodal transport document, where forwarders document were presented or multimodal transport operators document was submitted. So this clarification has come in SPP. If the credit indicates freight forwarders document not acceptable or a house document not acceptable, then there is no meaning for such a clause. What it means, this statement that freight forwarders multimodal transport document not acceptable does not give us any clue about what is the title, format, content or signing which is not acceptable. So as long as because this is not explained in UCP and ISBP, and because the credit has to explain what should be the requirement and how it has to be issued and how it has to be signed. If the credit does not explain what is the requirement, how it is to be issued and how it is to be signed, and if it just says document not acceptable, then it has no title, format, content or meaning with respect to the transport document. And then if this is not clarified, Article 19 will be applicable for checking those documents, because this statement or clause in the credit will have to be discarded. The multimodal transport document has to be signed in the form prescribed in Article 19A1. How it has to be signed: as agents or carrier, who is those specifications given in UCP. Article 19A1 has to be followed. It has to indicate the name of the carrier identified as carrier. So carrier has to be identified, and when it is signing, it should indicate the name of the carrier. When agent is signing, agent should say agent is signing for and on behalf of whom. It should indicate for and on behalf of whom. So capacity and identity. When you say as agent for carrier, capacity is agent and identity is as agent for the carrier. So name of the agent should be there, name of the carrier should be there. Identity of the carrier should be revealed by mentioning their name. Name of the master need not be cited. When the agent is signing for master, master's name need not be there. When master is signing for carrier, master's name need not be there. And the carrier has to be identified when agent is signing for the carrier. When master signs, name of the master need not be submitted. Master is signing as master is signing as carrier, as agent for the carrier. Either way, name of the master is not required. Let us turn our attention to the onboard notation related aspects. The issuance date will be deemed to be the date of receipt, date of dispatch, date of taking in charge, date of onboard, or date of shipment. A transport document may indicate a date of receipt, the date on which the goods were received by the multimodal transport operator. Date of dispatch is the date on which the multimodal transport operator is dispatching the goods. Date of taking in charge is the date on which the documents were given into the charge of the transport operator. Date of shipment or date of onboard is the date on which the goods were allowed to be moved out. These dates will be considered if available on the transport document. If there is an issuance date will be deemed to be the date of shipment. If there is a separate dated notation evidencing receipt or dispatch or taken in charge, such a date or such an onboard date will be considered as date of shipment. This date of shipment is of significance because we will be looking at last date for shipment given the credit and the period of shipment given the credit, and for these two aspects we will look at the date of shipment. So this is the date on which really the supplier had parted with the goods. If the credit requires shipment to commence from a port, if the credit requires that shipment has to happen from a port, which means the port of loading is the first point where the carrier receives the goods, then the multimodal transport document should indicate a dated onboard notation, because it is receiving on a port. It will become technically a port-to-port BL for that leg or for that aspect, and so an onboard is compulsory to ensure that goods were really on the vessel and not just received on the land. And the named port should appear on the port of loading field. The port indicated in the credit should be there, and the BL should have a port. It should not just say a port, it should say the actual port on which the onboard is happening or the goods have been received. Or there should be an onboard notation if the named port is not mentioned in the port of loading field, but if it is mentioned in any other field. So port of loading field will be the first point of check, and thereafter we will look at if it is mentioned in any other field like place of receipt or place of taken in charge. Then there should be an onboard notation that says goods were laden on board on the specified port, on the specified vessel with a specified date. That date will be the shipment date, and that port will be considered as the port of loading. The document should indicate the place of receipt or dispatch or whatever stated in the credit. So the transport document should say the goods are starting to move or start being carried by the multimodal operator from the places stated in the credit, and the country need not be stated. And if it says Chennai, India, India need not be mentioned. When the credit indicates a geographical area or a range, then the transport document should indicate the actual place. When it says any Asian port, any Indian port, any Arabian port, any American port, you have to have the transport document evidence the actual port from which the shipment had happened, and the range need not be mentioned. When you say have any European port, you can say just Frankfurt, and then other further indication is required. It should have a shipped on board. If the credit says it should have a shipped on board, the transport document may say shipped in apparent good order, laden on board, or clean on board. So as long as the word shipped or on board is used in any clause or phrase, it will be considered as shipped on board to fulfill the requirements of the credit. Now let us look at the place of destination and related things. When the credit requires shipment to be effected to a port, this is regarding destination or discharge. When the credit requires a multimodal transport document and it says it has to be effected to a port, then the named port of discharge should appear on the transport document. The named port of discharge should be there. Port of discharge field should have a port, and if it doesn't have a port and the port is mentioned in any other place like a place of final destination, then there should be a notation saying the port of discharge is same as the place mentioned under place of destination field. That is required. This is a reverse of the onboard notation at the point of loading. It should indicate the place of final destination. The transport document should indicate the place of final destination, port of discharge, or the airport of destination stated in the credit. The transport document should say the final point. The place of taken in charge is a place from where the multimodal transport operator receives the goods, and place of final destination is a place where the multimodal transport operator hands over the goods to the party who is buying under the documentary credit, where he could be the consignee or could be a party to whose order the consignee had endorsed this document or endorsed the goods. The name of the country need not be stated. So when it says a shipment to Paris and then comma France, then France need not be mentioned. Only Paris can be mentioned in the transport document. It is acceptable. When credit indicates a geographical area or a range, then the actual should be mentioned and the range need not be mentioned. So when it says a shipment to India and it does not say a place, the actual place called maybe Chennai, Mumbai, New Delhi, anything can be mentioned and the actual country need not be mentioned. The transport document issued and presented under the credit should indicate the number of originals that has been issued. It should say 2/3, which is 2 originals and 3 non-negotiable copies. Like that, it should say 3/3, whatever it is. It should indicate. And indication like first original, second original, third original, all original, duplicate, triplicate will all mean each of them are originals of equal value and weightage for the purpose of Article 19 of the UCPDC. Now, when consignee, order party, shipper, endorsement, and notify party related aspects. Consignee. When the credit requires goods should be consigned to a named entity. When the credit talks about a named entity as a consignee to be consigned to, then it should be straight consigned and not to order, which means it should not contain the expressions like to order of, or order. It should not say to the order of National Commercial Bank. It should not say National Commercial Bank or order. It should just say consigned in the field, respective field as National Commercial Bank. Consignor is a party who sends the goods and consignee is a party in whose favor the goods are being sent as required in the documentary credit. If the credit says the transport document has to be issued to order or to order of a shipper, here it says named entity, consigned to named entity, here it says to the order of a named entity or shipper, then it has to be endorsed by the shipper or by a named entity in favor for and on behalf of the shipper. When a transport document is issued to order, it is considered to be many times negotiable or transfer of title is possible. How it is possible? By endorsement and delivery. To permit such a transfer of title, and especially when it is in to the order of the shipper is nobody but the consignor or the applicant of or the beneficiary under the LC. He is the shipping the goods. So the beneficiary has to endorse it, or somebody on his behalf should endorse it, and that is why we say it has to be endorsed for and on behalf of the shipper when it is issued to order of the shipper. Why? To enable the goods or the title under the goods carried by the transport document to be passed on to the issuing bank and further to the applicant under the credit. If the credit requires for consigned to the order of a named entity, consigned to shipper, consigned to the order of named entity, consigned to a specific party. These are the three venues. These are two orders where it is negotiable, and this is state consignment. And if it is asked to be consigned to a named order of named entity, it should not indicate it is state consigned. If the credit calls for consigned to the order of a named entity, it should not be state consigned. If it credit calls for a state consignment, it should not be having to order. So this is regarding consignee. Regarding notify party, if the credit stipulates the details of one or more notify parties, the multimodal transport document can mention one of those and additional notify parties, same as been stated in the credit or other parties. If X and Y are mentioned here it can be X and Y, X and Z, X, Y and Z. Anything can be there. If the credit does not stipulate details of the party, then any party in any manner can be mentioned as a notify party. If the credit does not specify the details of notify party, transport document can mention any party in any manner. If details of applicant are mentioned as notify party, then it should not conflict with the details stated in the credit. If details of applicant are mentioned as the notify party in the transport document given, and if the credit does not stipulate any other notify party, it should just the applicant details should not conflict with the credit. If the credit requires consigned to or to the order of the bank, or consigned to or to the order of applicant, or notify to the applicant or notify the issuing bank, if the credit calls for, either to be notified or to be consigned to issuing bank or the applicant, then document should indicate the name of the issuing bank or applicant. The transport document should indicate name of the applicant or the issuing bank. If the credit calls for this parties, issuing bank and applicant, to be either the consignee or the notified party, and the transport document need not indicate their addresses or contact details. This is only for the purpose of identification of this, and then it need not indicate the addresses or contact details. But here, when the credit does not stipulate and the transport document or the shipper consciously adds the applicant's name, then the details should not conflict with the credit. It doesn't say it should be same as in credit, it says should not conflict with the credit. Now, address and contact details of the applicant that appears as a part of consignee or notify should not conflict with those stated in the credit. Again, the same thing what we are saying here. When the credit does not specify a notified party, if you add the applicant as notified party, it should not conflict. If the notified party or issuing bank is considered as, if the address is mentioned and contact details are mentioned, then it should not conflict. Not necessary to mention. If mentioned, it should not conflict. Earlier, we have had situations when certain banks were calling the fax number is wrong or PIN code is wrong, etc. And people had gone to ICC for opinion, and there had been clarifications given saying the PIN code can be different because a different office of the beneficiary or the applicant is being addressed here, and that is why it is different, or fax number has got changed and things like that. And so there was also guidance given that if a notified party details is given by the credit, and even if the shipper and other parties know that the information is wrong, still it should be same as in credit. A wrong fax number or a wrong PIN code will have to be mentioned in the notified party field if the credit specifies the details of notified party and the details is given. If the credit does not specify, addresses and contact details need not be mentioned, and if mentioned, should not be conflicting with. Trying to look at what is transshipment or partial shipment. In a multimodal transport situation, transshipment will definitely occur. Why it will definitely occur? The very purpose of having a multimodal transport document is that multiple modes of shipment will be used, because the credit had called for or allowed for shipment in more than one mode. Either it calls for a multimodal or a combined transport document, or it says a place of receipt to a place of final destination, which requires the multiple modes of transport. So transshipment will occur. There is no way a multimodal transport document can be issued without a transshipment. What is a transshipment? Transshipment is unloading and reloading of goods from one means of conveyance to another. It can be on the same mode or a different mode. One means of conveyance to another on the same mode or a different mode. We have earlier seen that mode of transport means mode by sea, by air, by road. These are modes of transport. Means of conveyance means a vessel, an aircraft, a truck. These are called the means of conveyance. So from one truck to an aircraft, or an aircraft to vessel, or vessel to truck, all these are called unloading and reloading from one means to another. It can be from one truck to another also. This unloading reloading should happen during the carriage from the place of receipt mentioned in the credit to the place of destination mentioned in the credit. Between the places mentioned in the credit, during the carriage of the goods, between the places mentioned in the credit, if unloading or reloading happens from one means to another means on the same or different mode, it is called transshipment for the purpose of this article. And such transshipments will definitely occur in a multimodal transport document. Now, what is a partial shipment? Partial shipment means shipment on one or more means of conveyance for this purpose. What is more than one means of conveyance? If goods are shipped, if two cars are being intended, one car is going in one vessel and another car in another vessel, it is called partial shipment for the purpose of this article. Even when such means of conveyance leave on the same day for the same destination. If both the truck, both the vessel, both the aircraft leave on the same day to the same destination, still it is partial shipment, because more than one means of conveyance are used for the purpose of this article. If a credit prohibits partial shipment, then more than one multimodal transport document is given. Suppose more than one transport is given under an LC which prohibits partial shipment. Shipment from one or more points of origin within the given range is indicated. Shipment from more than one points within the given range is indicated. Then it should indicate shipment on the same means of conveyance, same journey and same destination. What does it mean? Suppose it's the transport document. Suppose the credit says a shipment from any European port. Credit also says partial shipment not allowed. Then multiple transport documents can be submitted. These multiple transport document can say shipment from more points within the given range. That is, more ports within the given range of any European port. So one port in Spain, one port in Italy, one port in Germany, one port in Portugal, can be used for shipment. More than one port in Europe can be used, because credit allows any European port, credit prohibits partial shipment. More than one transport document can be given, but it should indicate same means of conveyance, same journey, destined for same destination. The voyage, same means of conveyance, it should be on the same vessel, and it should be the same journey. It cannot be a different voyage. The vessel should be on the same voyage, and then the goods should be destined for the same destination. All the goods should be going to, say, Jeddah, Saudi Arabia. So this is how it should be. If it incorporated different dates of receipt, if it is having a it should have a same, if it is a multiple transport document and if there are multiple dates of receipt, then latest of this date will be used for calculation of presentation period from the latest date. If it is one is 1st January, one is 1st February, then the latest is the 1st February, that will be considered for calculation of presentation period. Presentation period is 14 days from shipment, 21 days from shipment, that will be calculated for the latest date from the multiple dates given here. And these dates should be within the latest shipment date. Latest shipment date given in the credit, and should be before that date, and the dates mentioned in the transport documents when you have multiple transport document with multiple dates of receipt. It will be considered as partial shipment if it is not in the same means of conveyance, if it is not in the same journey or same voyage. You can also have a situation where it is an aircraft. Aircraft will have 2-3 touchdowns, maybe it will from Paris to Frankfurt to Berlin, then it flies across to Russia, suppose, and then it can have this. It's the same conveyance, same means of conveyance means same aircraft, same journey means the same flight, though it has layovers at these airports, and if destined for the same destination, say Moscow, it will not be considered as partial shipment, and it can be acceptable because it's a multimodal transport document, and this is an air mode leg or air transport leg that we are discussing here. If partial shipment is allowed by the credit, and if more than one transport document is submitted by for the presentation by the beneficiary, then if it incorporates different dates of receipt, earliest of this date is considered for presentation period and earliest is considered for latest shipment date. If partial shipment is prohibited, if there are multiple transport document with multiple dates, latest date will be considered. If partial shipment is allowed, if more than one transport document is there with different dates, earliest of this date will be considered. So if partial shipment is allowed, earliest date should be taken. If partial shipment is not allowed, the latest date will be taken for arriving at the presentation period as well as the latest shipment dates. What is clean? Clean means the transport document should not indicate a clause or should not have a clause which says anything about the goods or package is defective. Express declaration of defective condition. This is the operative part of the clause. Express declaration of the effective condition. So what is a defective condition? The goods are not okay. Goods are rusted, or maybe packing is broken. So packing may not be sufficient if it says it is not a unclean document. Packing is not sufficient which it means it is declaring the packing is defective. So this is how we look at it. It is not necessary for the word clean to appear, and the deletion of the word clean does not declare a defect. So this is about a clean. What is a clean? A clean transport document will be called for by the credit, and this is what we interpret by the clean. What is a description? Description of goods. The description of goods indicated on a multimodal transport document may be in general terms, not in conflict with the credit. The description in transport documents can be in general terms, not in conflict with the credit. It can be in bits and pieces. It should not be in conflict. It need not correspond to what is in the credit. It need not be a mirror image. Only thing is it should not conflict with. Regarding delivery agent, we have seen situations where the LCs will call for the delivery agent should be mentioned in the transport document. Why it is required? At the destination port, the applicant will not know whom should be approached to get the goods delivered that has been carried by this particular transport document. Who is the agent of the multimodal transport operator or the carrier? To find that out, we ask for a delivery agent. So when the credit requires to indicate the name and address and contact details of the delivery agent, credit will ask for name and address and contact details of the delivery agent. And the transport document will indicate the delivery agent, but that address need not be in the same place as a final destination. For example, if you have a shipment to France, the delivery agent need not be in France. A delivery agent can be in Spain, delivery agent can be in Italy, delivery agent can be in Germany. So when the credit requires details of delivery agent to be indicated in the transport document, the address of the delivery agent mentioned in transport document need not be located at the same country as the final destination. It need not be indicated. It need not be in the same place as final destination. It need not be the same country as final destination. So when the shipments are going to Barcelona in Spain, it can be the delivery agent can be in Spain, delivery agent can be in Barcelona, delivery agent can be outside Spain also. So it can be in Barcelona, it can be outside Barcelona in Spain, it can be outside Spain. Not if there are corrections in the transport document and if you have non-negotiable copies submitted, these need not be authenticated. If originals are submitted, any correction has to be authenticated. By whom? By the carrier or master, or by any agent acting on behalf of the carrier or master. This agent need not be the same as the one who issued the transport document. It can be a different agent, but that agent should be acting as agent for the carrier or as agent for the master, and they should indicate the carrier and they should indicate the identity and capacity of the particular agent who is authenticating. Freights and additional cost. Now regarding freights and additional costs, normally the credit will say cost additional to freight will not be allowed. That the credit is saying additionally because of the fact that if the transport document and the goods covered by it had to be taken over by the bank will be having additional liability over and above what it envisaged when issuing the credit. That is why the banks are writing freights additional to cost, not allowed. Also, the applicant would have had a particular budget when this underlying contract was signed, and then if additional costs are coming up here in addition to whatever has been mentioned, then they could be in trouble because of the shooting the budget issues. So, a statement indicating payment of freight need not be identical to that stated in the credit. For example, if the credit says freight payable at destination, the LC may say, the transport document may say freight collect. If the credit says freight payable at destination, the transport document may say freight collect. That is what we mean when this which says the statement in the transport document indicating payment of credit need not be identical to that stated in the credit, but should not be conflicting. If the credit says freight collect, the transport document could not say freight prepaid. It should say freight collect, or it should say freight payable at destination. This is regarding freight. Then additional cost. When the credit says additional costs are not acceptable, when the credit says additional costs are not acceptable, then the transport document should not indicate cost additional to freight have been incurred or will be incurred. When the credit says additional costs are not acceptable, that is additional costs additional to freight is not acceptable, the transport document should not indicate cost additional to freight have been incurred or will be incurred. Now, what is this cost additional to freight and how it will be indicated? The cost additional to freight could be because of cost covering the late return of containers, the cost as a result of delay in unloading the goods, or the cost incurred after the goods have been unloaded. These are some of the costs which are additional to freight related to the transport. When there is a delay in the berthing of the ship, delay in the ship leaving the port, delay in the containers unloaded from the ship, delay in the containers being emptied, delay in an empty container being returned. For all this, there will be cost applicable. Either the port will charge or the carrier will charge the parties related to the transport. Either the consignor or consignee, they will charge. And ultimately, because it is a consignee or the applicant under the LC who is going to release the goods, ultimately it will fall on them, because unless it is paid, they will not release the goods, the carrier. So, these cost additional to freight is not applicable. It's a standard requirement under most of the letter of credit to safeguard the applicant from such additional cost. And these are the costs, the demurrage cost or the detention cost, or mostly the cost letter. And these cost of late return of container or cost of delay in unloading are not considered as cost additional to freight. So, these three types of costs which are related to the transport are not considered as costs additional to freight. These are the costs that could be delivered. These are not an indication of cost additional to freight. Then what are the costs additional to freight? It could be mentioned by using an Incoterm. Instead of CFR, if you have a CIF, then there is an insurance cost in addition to the cost of freight, which will be billed in some form somewhere. Or you could have an Incoterm used, FIOS, free in and out stored, FIO, free in and out, FI, free in, FO, free O. These Incoterms could be used along with the already agreed Incoterm, CFR, FOB, whatever. Along with FOB or CFR, you can use this FI or FO or FIO or FIOS and which means the cost incurred in moving the ship into the port for berthing, into the terminal for berthing, and then moving the ship out into the sea. Those costs are covered or not covered, and if it is not covered, who will be payable? These are the costs additional to freight, while these costs are not considered as an indication of cost additional to freight. This clarification was necessary because we have had situations where sorry, international banks had refused a presentation saying detention charge or demurrage charges mentioned. And so banks started writing in their letter of credit that 14 days free detention period has to be indicated in the credit. So that if there is a 14-day free detention period, before that free detention period or before the costs are being applied on those containers, the applicant will be able to release those goods. When there is a situation where more than one document has to be surrendered, how it happens? Container X is covered by BL number Y and BL number Z. One container is covered by two BLs, or the two different parties have shipped goods and their goods are put into one container, and at the destination point the carrier will not release a container unless both the BLs are given. So what happens is, if both the BLs are not presented by the same party under the same presentation, and if it is with another party, until and unless that party is willing and ready to come and submit that particular BL, the container cannot get released. When the container is not released, the holder of the first BL will not be able to get his goods. To avoid this risk, the transport document should not expressly state that the goods will only be released upon surrender of one or more transport documents. The transport document submitted should not expressly state that the goods will be released only upon surrender of one or more additional transport documents. If it states, then we have to check whether all such transport documents are part and parcel of the same presentation. If it is not part of same presentation, the applicant under the LC will not be able to get the cargo released because he doesn't have access to the other transport documents that have been called for to have the shipment released. So this is what the situation where multiple BLs are required to cover a particular portion of shipment or particular container of the shipment. So we have seen in brief what the transport documents, what a multimodal transport document envisages, and what is covered by ISBP. Thanks for watching this video, and we shall meet again on another session on the next transport document.